everyone, welcome back to our YouTube channel. And if you are interested in close corporations or you are a member of a close corporation, then you will find this short clip very interesting. So today we're going to explore the benefits of an association agreement, the format of such an agreement, and what happens when one or more of the members passes on. So as a member of a close corporation, you should always understand the importance of having an association agreement in place. This is usually the starting point, and this is an agreement that regulates the relationship between members of a close corporation. It is also a side note, it is not compulsory to have an association agreement in place. So what is an association agreement exactly? An association agreement provides the rights and obligations and duties of each member of a close corporation. It provides the percentage that each member of the close corporation has and each member's voting rights in the close corporation. In the agreement, or the agreement also needs to provide for dispute resolution in the event of a conflict between the members. So you'll have a clause explaining what happens in this such circumstance. There are many benefits of an association agreement. So in terms of the Companies Act of 2008, not the old one, I think the old one is 1973, if I'm not mistaken. However, there's a new one that got enacted in 2008, which states that no new close corporation may be registered. And the existing close corporations can, however, convert into a company or remain as a close corporation. Now, from experience or from what I've learned, I know that a close corporation is also very easy to, or used to be very easy to start up. And also people used to form close corporations just to avoid the legal process that starting up a normal private company or public company would take. So a close corporation gives you as a member the power to be a separate entity from your business as well, but also having the benefits of, for example, a partnership or a sole proprietorship, but also the benefits of a company. So when remaining as a close corporation after the enactment of this act, there are benefits that does flow from an association agreement, which is that, for example, the agreements will identify all cases requiring the solvency and liquidity test to be applied, the members' authority, which is always clearly identified in such an agreement, and members also enjoy the business judgment rule protection, which is a legal principle in South Africa that protects the members from personal liability for loss incurred in the business transactions that are within their power to make when sufficient evidence demonstrates that such transactions were made in good faith. So the format of an association agreement is quite basic. However, there is no prescribed manner relating to this format. But like any other agreement, the association agreements must be signed by all members in the presence of at least 2 witnesses and initialed on each and every page. All members also need to have a copy, and the original agreements will be kept by the close corporation's attorney, and a copy also needs to be kept by the registered office of the close corporation. So new members will be bound by the existing agreement as if they were the ones that signed in the beginning of the agreement. So an association agreement will typically contain the transfer of members' interest, dispute resolution processes, what happens if there's a breach of an agreement, where the address of the close corporation, where notices and letters and everything regarding the close corporation should be addressed to. It will also state who each and every partner or member in the close corporation is, how profits and losses will be divided, and so on and so forth. What also happens when one or more of the members passes on, for instance? So how do you transfer a deceased member's interest? So where a member of the close corporation dies, the disposal of his member's interest should be provided for in the association agreement. He can also dispose of his member's interest in his will, and this is protected by Section 35 of the Close Corporations Act. So in conclusion, it is not compulsory to have such an agreement. However, it does make life simpler and much more easier, and it makes provisions for disputes and how the close corporation should be managed and disposed of at all times. So it is also always important to have an agreement in place, because without an agreement, how can the courts protect you if you saying one thing and the other partner saying another thing and there's no physical evidence to back it up? I hope that you've enjoyed or learned something from this video, and if you did, please like and subscribe to this YouTube channel, and also click on the bell button to get notifications for the next video. Thank you so much for tuning in.